Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donowa, attorney at law, and once again I'm happy to be here. Once again I'm happy to bring the law and you. Of course, you can stream us on our World Wide Web at wesncc.com as well as traditional media. Also, you can catch us at Strictly Legal with Rondell Donowa podcast. Now, today I am, of course, always excited, but we are introducing to Strictly Legal a new segment called Legal Lingo. And basically, this is where each week we will put forward a legal term and we will present this to you in terms of a context of whatever matter we are about to discuss. So, let's begin. Today on Legal Lingo, we will discuss the word provocation. Now, provocation is causing someone to lose their self-control by doing or saying something, let's say, for example, such as threatening to harm a baby, which would cause a reasonable person to temporarily lose their self-control. Let's use the word provocation in context. A man, in his defense, has indicated that he committed the offense because the person provoked him. And therefore, he said that that's provocation. So, as you see, I use that in a phrase, and of course, we'll be discussing that further. So, here you have it, Legal Lingo on Strictly Legal, WESN Content Capital. We'll be right back.
This is Face of Sports, WESN Content Capital. How you felt about the kiss on the lip?
That's the business. I'm not to do with that.
I find that was distasteful.
The national senior team, whether you like it or not, that is the model for all other teams to follow.
I'm assuming that the regional requirement may be a much stricter requirement.
This is not about Pro League and Super League. This is a league run by the Normalization Committee that I'm responsible for.
Nobody expected FIFA to fund this arrangement.
If we don't get a professional attitude towards this, we are doomed for failure.
You break the balance, trip the leg, control the body.
They ain't gonna stand put forever.
Why you want the Chiefs to lose so? Why you want the Chiefs to lose so?
They already have two. Lamar don't
Why?
have.
You're jealous because you know the Chiefs getting closer to the Patriots. Let's go to the last part.
No,
of the
not no.
Let's go to the last part.
Welcome back to Strictly Legal, where we will be discussing today a very, very important and provoking topic that deals with the controversy of intimate partner violence. Of course, in the context of self-defense or provocation. And of course, we have no stranger to Strictly Legal, Mr. Daniel Ishmael Khan, who of course is an experienced criminal defense attorney, as well as he was a former inspector of prisons. And he's here to speak on the topic today, breaking point. Yeah? Welcome, Daniel. The controversy of provocation in intimate partner violence. Welcome once again.
Yes, thank you. Thank you, Donovan, and thank you for inviting me to discuss this topic of provocation. I watched your last show on the case of Elsie and her situation, and it really raised important issues about the law. You know, the lingo, we would say, a man provoked me. I was provoked. And we talk about loss of self-control, which is very common in Trinidad. In the papers, we're reading about all these murders, men committing against women, and then many of them taking their own lives. And I think it's a very important public issue to discuss on this matter.
Of course, and as you indicated, you know, in this mini-series in terms of exploring domestic violence, or rather gender-based violence. On the last occasion, we would have discussed where the wife of her deceased husband now, she used self-defense. at the point in time, and this is why the murder was committed, not intentionally,
Yes.
but of course because she was provoked,
Yes.
or rather she was abused on multiple occasions, and then that night in question, that morning in question, because of the severity of the abuse, she had no choice but to do the act.
Yes, and anyone who watches show, I would suggest watch show. It speaks to the issue of reform. Here was an abused woman over many years, and were documented reports at the police station, and then one day she acted in self-defense, but her stab wounds were so many. She inflicted more than 15 stab wounds on the deceased, and therefore one could argue perhaps it wasn't self-defense, and she had to rely on provocation. Provocation is a partial defense to murder, which reduces murder to manslaughter. Thankfully, she was allowed time served, and she came out. She is out. She's in the free world, but the law itself poses many, many problems.
So let's, as we're on that discussion, let's talk about the evolution of the term or the defense of provocation,
Yes.
Particularly in today's context.
Yes. Well, for us lawyers, the word common law is a phrase we're used to. Common law is judge-made law. You won't find it in the legislation. It wasn't passed in Parliament. Murder is a common law offense. We've had it for centuries. The English had it, and we imported it through our development of law. The partial defense of provocation was imported in our common law, but it's developed in Scotland. And what it meant to do was mitigate the harshness of the penalty of murder, which then, and well, still is in Trinidad, but then in England was the death sentence. And it was called a concession to human frailty, because we are humans. And I said before, a murder can occur in infinite circumstances. But the concession the law developed, judge-made law, common law, because of human frailty, because we all lose our temper, we will diminish the murder charge to a manslaughter charge based on the partial defense of provocation. Unlike self-defense. Self-defense is a complete defense. You're charged with murder. If the jury or the fact finder accepts self-defense, not guilty. If the jury or the fact finders agree with your partial defense of provocation, you're found not guilty of murder, guilty of manslaughter. And provocation developed to mitigate the death sentence.
And therefore, is it that, of course, the partial defense of provocation has been there for centuries?
It has been there for centuries. In my research, in 2009, it changed in the UK by statute. They call it loss of self-control. I'll return to that in a little while. And currently, although many Commonwealth jurisdictions have the partial defense of provocation, the only two jurisdictions that really have it are Trinidad and, from my research, Hong Kong. And the partial defense of provocation arises very, very often in spousal killings, intimate partner violence. Because we all know, I wouldn't say romance is a heated thing. You argue, you know, and then the loss of self-control can come up. And we see in the papers it comes up, and fatally comes up, as your topic says. And it's to be examined, because we don't want a society that excuses people for losing their self-control and killing. Yes. And we want a society where each gender is equal. And often, the 5 cases I will discuss that I was in over my 15 years, it is men killing their exes post-end of the relationship. So it is intertwined with the human frailty, but it also, it needs reform.
And of course, as you mentioned, and I was getting to there in terms of you representing 5 men throughout
Yes.
a period of a couple of years,
Yes.
who all have different facts, but are ultimately the similar circumstances.
Yes, yes.
And this is a discussion that I would like us to go through in terms of exploring the different facets or the different facts and what the court took into consideration, whether or not the court actually decided to acquit by virtue of a jury, or whether the jury decided to acquit someone or any of your clients based on that defense, or based on whatever intricacies or in law that may have arisen throughout the process of the trial.
Yes.
What is your take in terms of how do you wish to proceed with
Well,
with that
chronologically, I think it's important. If I could take your viewers and you through the first case, Ramesh Sunarayan, it was decided in November 2006. This was a prisoner that was committed for murder of his ex-girlfriend and pled guilty to manslaughter on the basis of provocation and was sentenced to time served, which was about 3 years.
But this was, from reading the case, this was a very interesting case in terms of he was in a relationship with this,
yes,
with this person. They got estranged. I believe that they had a son.
It was
together.
his son. It wasn't hers. It wasn't his.
Son.
Yes.
So if you could just let's walk us through the facts.
Yes.
In terms of what really happened.
Yeah, permit me to read, because I don't want to get anything. So the prisoner was in a relationship with the deceased. He had 2 children from a previous relationship. And one day, the deceased picked up the prisoner's son and inflicted serious violence on him. It is alleged she tied his hands onto the car's headrest, behind his head with one side of his shoelaces, tied his neck with the other shoelace, and cuffed him on his abdominal area and telling she's fed up with him. She stopped the car on a dirt road and beat the child in his head and hands with a wheel spanner. The child was eventually dumped onto a pile of rubbish, which included chicken entrails, and she drove off.
How old was this child?
That child was about 10.
Oh, wow.
Yeah.
But what would cause an adult to be so fed up with a child
to
do that extremely cruel act?
They never got into it. She was charged for attempted murder of that young boy. And later on, after the incident, her and the prisoner meet and they start to talk. And she brings it up. She brings up the incident. This is the first time. This is according to him. And he relies on the partial defense of provocation. He said when she brought it up, he just saw the image of his child, battered and bruised, and he grabbed on her neck and strangled her till she died. He put her body in the car and drove her around on the bus route aimlessly and ended up going to the police station, turning himself in, confessing fully to it. Now, he has killed a person. Yeah. That is murder. Yeah. No one else was around. No one else can say the circumstances. He confesses to what he did. There's obviously the factual history that she has been charged for attempted murder. Yeah. So that is something that, corroborates what he is saying. There's no bail for murder. It's about 4 years. You go through the PI. He gets to the High Court. We write. I had just become an attorney. This is why it's so. I became an attorney in September 2006, and I got the case in November 2006. Obviously under the guidance of Head of Chamber Senior Counsel, and he pled guilty to manslaughter. And the DPP accepted that, and the judge gave him time served. Now, any person.
And if you could explain just to the viewers and listeners,
yes,
in terms of what is time served.
Well. Okay, murder carries a death sentence, mandatory, and then manslaughter will carry as much as life. But you can get a term of years depending on, so he was in jail for about 4 years, and the judge looking at the mitigating factors, those are serious provocative acts. Any reasonable person could say, harming my child, your legal lingo, and the example was a harm to my child. That is a natural human instinct. You harm my child, I'm going to, lose my control, my emotions and all that. And the judge thought, based on the facts that the severity of the provocative acts towards him, the fact that he confessed, the fact that he has pled guilty, that the 4 years would have satisfied the principles of sentencing. And that is one case you'll hear anytime I talk about it, common people saying, well, I accept that.
And then how much time served?
He was waiting for 4 years. So they said the 4 years that he was in custody would satisfy, and he was allowed to go after he pled guilty.
No, you mentioned, I believe somewhere in your submissions,
yes,
you mentioned that this attack was spontaneous. It lacked premeditation.
Yes.
But what is the circumstances that you are that arose to state that it wasn't premeditated, despite the fact that he remembered what would have occurred? They had a discussion, and then immediately he strangled.
Well, that is the essence of the question, because murder is a contemplation and intention. The concession to human frailty for the partial defense of provocation deals with a sudden and temporary loss of self-control. And that is why we're giving you manslaughter, because it was sudden and temporary. You can't rely on provocation, the partial defense, and you provoke for a month. That is premeditated.
Yes.
So it's because of, it's hard to judge a man, in this circumstance. But he met up with the lady after the incident, and she said, according to him, he brings up the act. So the spontaneity of the incident is she bringing up the act. And that is how he was able, and the DPP accepted based on the confession and the various facts that he could rely on. And he pled guilty. There was no trial. He pled guilty and he was sentenced. And this was in 2006.
So he's basically a free man?
He was out at the time, yes.
Now, of course, this is obviously a sensitive situation.
Very.
In that, whereas, yes, we are discussing persons who committed murder, many viewers or listeners may be of the view that, okay, this comes as though you are desensitizing or you are accepting murder by time served of 9 years, 8 years, and whether or not that is indeed just for human life to be lost and having to now serve little to no time.
Yes, the aims of punishment require retribution and denunciation, meaning by our sentence we are making the statement that this type of act is not to be accepted in society. But there are infinite amount of ways killings can happen. The scale is reflected on the sentencing. Many people, provocation kind of has a broken down to a Trini slang can say, well, she looked for that, And although we think laws are above us, laws kind of meet the common man's view of it. This man did not go unpunished. He spent 4 years in jail. Was that sufficient? It wasn't for me to say, but based on the case law, because of the provocation so severe. But some of the other cases will probably shock when you come to the amount of time served.
Yeah, and as we are on that discussion, let's speak to another matter that you would have the defense counsel on in terms of the state and it's
Vishnawat Sharma. Yes, it's in 2012. He was convicted. He was charged for the murder of his ex-girlfriend, and he had killed her by about 15 chops. Cutlass. It was terrible. One of the police officers said that her face was spliced off. It was situations. He had to go through a full trial, although we requested a plea to manslaughter. The DPP rejected it. We went to full trial. The jury found him not guilty of murder, guilty of manslaughter on the basis of provocation.
So let's discuss in terms of the facts. I know that it was a matter of alleged infidelity.
Yes.
That would have caused an act, but if we can just, for our viewers and listeners' benefit, in terms of how it led to that act.
Yes, sure. If I allow to read, the prisoner and the deceased had been lovers from some time in 2000 when he returned to Trinidad. They entered into a relationship about 3 years, and sometime within the relationship it ended, and it appeared that she moved on. In his mind, he would consider that they were still together. He gave evidence that she said many things to him. I mean, this is coming from him. She is dead. She cannot refute it, but the jury had to accept some of these things. He's considered that during the 3 years, the deceased had been disrespectful, insulted him, physical abuse, assaulted him, open engaged in infidelity, insulted his manhood, say you're just a mattress, you're here just to provide a place, don't tell me what to do, all these things.
And more striking is that in his case, he would have indicated that he was in love with the deceased.
Yes.
Obsessed in love, as his
Yes,
counsel,
well,
as you put it. And well, as you said, she used physical violence on him
Yes.
on many occasions.
Yes.
Were there any witnesses to support Mr. Sharma's Mr. Sharma's
no.
case?
There was no witnesses. I mean, you know, the things about it's between often partners. So it's going to be two people. When two people quarrel, they tend to try to do it in the privacy, away from people. So she being deceased, he being alive, it was only his word. But he had to give evidence, sworn evidence, subject to rigorous cross-examination by the state. And the jury accepted his. That is how we find facts. We take it from evidence and we let the fact finder tell us what the facts are. They accepted that he was suffered for emotional and psychological abuse to the point that it caused his loss of self-control.
So was this a spur of the moment situation as opposed to the previous man? Case?
Well, he gave evidence that it was a spur of the moment. He went to her house and she left the bedroom, she went to the kitchen, and she pulled a cutlass on him. This is according to him.
Right.
But of course, the jury accepted it. We have to treat it as facts. And then as they're talking, she starts to tell him more of the stuff, and he said it all came back to him. He say what we call the last straw or the breaking point. You can have cumulative provocation that, yes, the last straw might be, let's say someone keeps hitting you on your sensitive point, and over a while it builds up, and they just have to mention it. You know, in this case, it was another lover called Marvin. So the Marvin thing comes in again, and according to him, he said it drew him crazy. He could not recall how he lost his self-control, and when he looked down, he saw her with cuts on his face, and he ran off. Obviously, they said there were 10 chop wounds to various parts of the body of the deceased, 3 to the face and head, others to the hand, the back, the lower limbs. One witness described her face as spliced off. An essence of provocation is a loss of self-control, often exhibited by a frenzied attack. Self-defense, they say, you know, a man should not have to weigh to a nicety the exact measure of defensive action when being attacked.
No.
But when, and it is how it developed, because provocation developed when you may have acted in excessive self-defense. So we're not giving you the entire not guilty.
Yeah.
It first developed, you could only rely on provocation when there were physical acts done towards you. So almost like, you know, a man's going to slap me. He didn't slap me. It's not self-defense because, you know, self-defense is fear of death. And I'm provoked to attack him. Later on, understanding human psychology that, you know, you can lose your self-control in reaction to physical acts like fear, or you can lose it on your emotional reaction like words. So the law developed, it includes words as well. And then in the words now is where it gets murky.
Yeah.
Because we as a citizens, we want law that control people's emotions. We can't be giving them too much of a bly for losing their self-control.
But then, how do you distinguish jealous rage?
Yes.
From just losing self-control? Because one can state that, well, based on her infidelity.
Yes.
Obviously, I was envious, or rather not even infidelity.
End of a relationship.
Let's say, for instance, yes, the relationship ended, you became jealous because she is with other people, and then in a fit of rage, he murdered her. That can't be provocation.
Well, it is, you are entitled to rely on provocation and whether the jury accepts it or not.
Right.
You know, in this case, it could be a bit of jealousy, but in England, they changed the law in 2009 to loss of self-control, specifically mentioning infidelity cannot be relied on as a ground for provocation. Because we understand the human nature of romance and relationships, and I don't want to say Caribbean men are any different or Caribbean people are any different, right? People are emotionally attached to the people that they are in relationships with, they love. And that is why, you know, loss of self-control. But the loss of self-control You cannot control yourself, you have lost it. And therefore, we're going to give you the partial defense. But I think it is time that we catch up to the English law and say, look, the horning thing is not sufficient for you to lose your self-control and get provocation. And I think that is where the law will be heading eventually when we get to the 2023 case.
Obviously, in our jurisprudence, I think it's a Caribbean thing. It's quite popular.
Yes.
If that's the correct term in terms of horning, or
yes.
as we say, local parlance, or
yes.
being promiscuous and stuff. It's quite common here.
Yes.
And therefore, if every man or every woman is to plead that partial self-defense of provocation based on infidelity, then many persons will feel as though they can commit an act, spend a few years in prison, and then return to society and integrate normal.
Yes, and it's a frequency. We read about it in the papers. If you do a little research now, I don't want to call a bunch of Caribbean names, but it happens in Guyana, it happens in Trinidad, it happens in the smaller islands, it happens all through the Caribbean. I mean, I was shocked at how many cases. It happened in Hong Kong. There's some case where a man, the case I relied on in the 23 Sean Marslin case, about 80 stab wounds to his lover, you know, and it's all this. It's time for reform of the law, because you want to make a concession to human frailty, but you don't want to excuse this kind of things.
Yeah.
Infidelity, end of romantic relationships, people moving on, promiscuity, all these things are part of human nature. You know, and as a human, you have to control your emotions, because the complaint with the law on provocation, it is gender biased. It often rewards the quick anger that men can get into, and doesn't recognize the woman's slow burn, like the case of LC.
Like when you say slow burn, the
slow
tolerance
burn
level is
right.
It's quite large. For instance, if a woman is to be cheated on, she may take a while before she actually explodes.
She doesn't
but
respond.
If a man is cheated on,
that
you explode in no time.
Yeah, a day for him to hold it in might be too much.
Yeah.
And it is wrong for us to, I mean, that is pairs. I mean, what we're going to say, we want to guide human nature,
yes.
or we want to accept human nature. And no matter what, anger management is important. And men, I mean, I'm not saying women don't lose their temper, right? But, I mean, we're seeing it in the papers on the frequency and intimate partner violence. Men often lose their self-control, being the physical stronger, and they often are killing their ex-partners, and in a sad, well, the whole situation is sad, loss of life is sad, but you know, the murder-suicide is too common.
Yes.
It is too common. We make jokes about you get horny, you drink Gramazone, murder. It is too common.
It's in our songs as well.
Yes, yes.
Sometimes, you know, that can have to me, that's probative to cause people. Sometimes music, remember, those are influence.
Yeah.
And the constant recording or the constant playing of those type of violent or those type of tunes that promotes an agenda, that plays with the psychology of one's mind. And it would be very interesting for us to even have let's say a sociologist or rather a psychologist to deal with the influence of music and crime.
Yes.
You know, seeing that is a big thing. Obviously, I know I segued. I don't want to segue too much in that aspect, but I think those things are integrated enough.
Yes.
Right, to understand the human mind, to understand what causes certain reactions, etc. That intertwines with criminality.
Well, the music, I mean, we have many horning songs, you know?
Yes.
And I think...
And we enjoy it and we sing it and we party if I get horn.
Okay.
A horn
is a horn only if you take it on, right?
Starting from shadow, straight up to, you know, and it's fun and it's whatever, you know.
You're looking for horn.
She horn you, I horn you back, you know, that kind of thing. But for those, of course, who are listening or viewing from abroad and don't understand the terminology, horn in our local culture, horn means being cheated, being cheated on.
Infidelity.
Infidelity.
Yeah.
That is basically
a verb, a noun. But it's a good message. A horn is a horn only if you take it on, you know. And that is why these these men, they took it on.
Or
you
look
know?
the other way, you know, as some person says. But let's streamline back into the discussion. I know we discussed the two cases where the provocation, self-defense, partial self-defense, worked in their favor.
Yes.
Based on the circumstances. Now let's look at the third case in which.
Well, there are two Court of Appeal matters. That is Uriah Woods and Sean Marcelin. Well, there are three in all. Uriah Woods and Sean Marcelin, along with co-counsel Natai Lachman, I argued in 2017. In Uriah Woods, the court rejected my argument. A short judgment, 16 pages. I mean, I gave them a lot of authorities, but they dealt with me. 16 pages is a short judgment, but yes,
well,
it is. Yeah, the Sean Marcelin is 75 pages.
Yes.
So now Uriah Woods, it happened in Tobago of his ex-wife, common law, and according to her, she moved on. And one day he went, this is perhaps 7 months after, 6 months after, to where she was staying. And he goes in the room and he sees a man on the bed. In his head, he thinks he's still in a relationship. He has children with this woman. And he gets in a fit of rage and he starts to chop. The man runs off and his own son, the accused's own son in the room, in a fit of rage, he chops off his own son's foot. And he kills the woman. He goes through a full trial. He's convicted of murder. They reject the partial defense of provocation. And
6 years old at the time that son was.
Yes.
Yes, 6 years old.
Yes. He is charged for attempted murder of the son or wounding of the son as well. But so he's convicted of murder. He relies on the partial defense of provocation, and they reject it. They reject it because, you know, he's going into another person's place. The jury reject it. Either they don't believe him, or if they believe him, they don't think it's enough for provocation. But the judge had made a comment on the law of provocation, which we complained that the Court of Appeal was wrong. The Court of Appeal didn't agree with us. Fast forward 6 years later, they agreed with us. And it said, was it reasonable to lose his self-control? But as the law developed, did he act reasonably after he lost his self-control, is what the judge said. You don't act reasonably after you lose your self-control. It's contradictory. If you lose your self-control, naturally your actions are after unreasonable. One cannot justify this kind of thing. So the Court of Appeal rejected these submissions, said we were trying to change the law, dealt with it in quick grip, 16 pages is short, and he remains convicted of murder on a...
But it's not only a matter of pleading the defense of provocation based on infidelity or whatever it is that in his mind. But what is striking is that the reason why the deceased left the relationship was because she suffered, based on the evidence, she suffered the years of domestic abuse.
Yes.
At the hands of the
prisoner.
And the prisoner.
Yes.
So therefore, if there's evidence to suggest that there has been years of abuse, a pattern, do you think in your mind, as his defense attorney, that you would have succeeded?
No. This specific case, the provocation was a difficult partial defense to put. But I can say it's often when people run provocation, the jury don't accept it. So the law is one thing, but when jury apply law and facts, if there's something called jury nullification, which is why Mr. Israel Khan and myself are so supportive of the jury, that we believe they are more common sense than the lawyers and the judges. The jury can be explained the law in a understandable way, they understand it, they accept that there is law. But if the law doesn't conform to what the common man law thinks is just, even if he was entitled, Uriah was entitled to provocation, the jury is going to say, no, that is a man, we're not giving him an excuse, convicted of murder. We took an extremely technical point on the appeal. It was rejected. I argued it at the same time as another case called Sean Marcelin, which I will get into after. And he remains on death row, convicted of murder, serving a current death sentence.
So he was And what year was he convicted?
He was convicted, I believe, in 2005, and the appeal might have come up in, 2015, the murder 2005, and the appeal come up 2 years later, 2017. So he's in jail about 20 years now.
So therefore it means that, I mean, based on the evolution of the law, I can't recall the case at the moment, and you could assist me as the experienced one. In terms of after one spends a specific number of time, 5 years in prison, then one could apply. Well, automatically, they are now placed in life. The sentence has been is now classified as the life imprisonment.
Yes. After Pratt and Morgan, which I think is mid-90s, they said delayed wait on death row is unconstitutional, and if it hasn't, you haven't hang the man in 5 years, you can't do it anymore.
Right, so therefore where that leaves him in terms of even applying for bail?
Yeah, no, he would be a convicted man. Bail really is.
Oh yes, bail is right.
But so he is awaiting an appeal in the Privy Council. I don't know when that happened, maybe a year, 2 years in the future, he will know his fate. But since...
Are you the attorney on record for that appeal?
No, I was the attorney on record in the Court of Appeal. I argued that case Uriah Woods and Sean Marcelin at the same time. Now, Sean Marcelin was, for several reasons, only decided 6 years later in 2023. A little victory in the sense that they said when they were wrong in Uriah Woods. The Court of Appeal came and said 6 years earlier we were wrong in Uriah Woods. Mr. Khan had a point when he was arguing this reasonableness of action. I remember being disappointed. You know, you put and this is a topic since 2006, good 15 years I'm reading this. And I went home and I kept on researching. I found myself on a Hong Kong website, you know, no nice term search. I'm just reading all these character things. And I see a judgment decided in 2022 exactly what I want to argue. And I submitted to the Court of Appeal. The Court of Appeal calls us back and really looks at it and delivers a 75-page judgment, you know?
Yeah, now we're speaking all these facts, but in terms of understanding, at least the viewers understanding what exactly we are discussing at the moment.
Yes.
In terms of the Sean Marcelin case, as you said, this is a big matter. This was the state versus Sean Marcelin. But let's get in terms of the facts.
Well,
in this matter that would have led to not the Privy Council, but the Court of Appeal stating that, well, they were wrong in their previous decisions a couple of years before.
Well, in 2003, Sean Marcelin, he killed his ex in a public stand in New Grant. She was there. And they both travel in the same area, and he approaches her and starts to say, you put me in court maintenance and this and that, and you said that I'm not paying maintenance, you're trying to get me locked up. And, you know, that's a heated topic, you know. And she goes in the maxi, he follows her, and he stabs her 20 times in a public maxi, a large, you know, not a sedan. A large maxi taxi, pulls her out and stabs her more in a public place another 20 times. He's later convicted. The offense is August 4, 2003. He's later convicted after a full trial. Convicted of murder. He gave evidence and the jury rejected his plea as partial defense of provocation. He's much like Uriah Woods, much like Vishnawat Sharma, and much like Ramesh Surnarayan. They all say, I do not know what got over me. I cannot remember acting, but I must have, you know. He attempts to commit suicide after that is Sean Marcelin.
But what I want to note particularly, and I would read in terms of the day in question of the killing.
Sure.
Particularly to advance whether or not really and truly provocation is necessary here. Now, according to the facts as continuing in the judgment, which of course these names are public, these are all public knowledge, public cases. It can be found on the judiciary website, etc. So therefore there's no need or concern in terms of disclosing the parties, okay? But particularly on August 2nd, 2003, a taxi driver was plying his maxi taxi for hire in New Grant, and around 6:40 p.m., while parked at a maxi taxi stand, the deceased entered and sat in the seat directly behind the driver's seat. The appellant, because obviously he appealed his decision, so that's the prisoner I would say, entered, and the deceased said, "Oh God, I tell you, don't follow me here." The prisoner asked the deceased if she had made an application to the court for a maintenance order against him. The appellant asked her, meaning the prisoner, this question 3 times, and the 3rd time, the deceased said, "Yes, I have you in court for maintenance." And the appellant asked her, "Why you have me in court for maintenance? You know when I work, I just mind my children and them. Now I am not working, I can't mind them. Why I do that for?" And the deceased replied, "No." The appellant again asked whether the deceased made an application for maintenance against him, and she said no, all right? There was a moment of silence that lasted approximately 15 seconds, and then the maxi taxi began shaking. The maxi taxi driver exited the maxi taxi and looked through the window and saw the prisoner stabbing the deceased with a knife. The blade was approximately 3/4 of an inch in width, and the maxi taxi driver told the prisoner to leave the deceased alone, but he continued to stab her. By that time, the maxi taxi driver contacted the Princeton Police Station and reported the incident, and after making the phone call, he observed that the prisoner and the deceased were outside of the maxi taxi. The prisoner dragged her to the back of the maxi taxi and continued stabbing. Then he left the scene. And it's only upon arriving at the facility, actually no, she was pronounced dead at the scene.
Yes, I believe so, yes.
Right? So these are some gruesome acts. And in terms of explaining the legalities of why he used provocation, and he used provocation because, well, in his mind, she provoked him based on the fact that she applied for maintenance. But at the end of the day, he followed her in as well.
Yes.
So whether that was premeditated,
yes,
that is something that I would like you to explain.
Well, at the trial, the state prosecutor obviously said it was premeditated. You had a knife in your possession, you followed the person there. This wasn't a happenstance meeting. You were the aggressor. She asked you to go away, and the jury rejected his partial defense. He gave evidence. The jury say either we don't believe that happened, or we don't believe that version of what you're trying to say. It sounds like you went there to kill her. So he's convicted of murder. Now, when you look at an appeal, one must look at the judge's directions and see if they were correct. Now, the facts could be 100% pointing to the murder, but if the judge gave wrong directions, which the Court of Appeal found that he did, on a very particular point, the trial would be the conviction would be considered unsafe. Right. And in this case, they substituted manslaughter for murder based on the error of the judge. The judge was the same judge in Uriah Woods.
Also, the judge in the lower courts would have
give a wrong direction.
A wrong direction of manslaughter.
On the provocation.
Okay.
It's a developing law. Remember, we rely on the precedents and the apex courts to interpret us. The judge, what he said is, do you think a reaction like that was reasonable? But the circularity of it is that once there's loss of self-control, all actions after are unreasonable. So the court said he had denied the accused realistic chance to get the partial offense of provocation. And that is why they quashed the conviction, they replaced manslaughter, they resentenced it, they sent it to the judge to resentence. I can't say how many years he will get, it's pending.
Oh, so this appeal,
is the sentence.
Okay, so the appeal would have been squashed.
Yes.
And it has gone back to the trial judge. And at this point in time, the trial judge has not...
No, no.
Well, it has not been
completed. The offense is 2003, so he's in custody perhaps 21 years.
So therefore the court, I mean, if now the court has to consider sentencing for murder,
yes.
I mean, at the end of the day, I believe it's no-brainer because there's no range of sentencing. I mean, you commit, in terms of that regard, whether or not the courts can commit someone to hang, considering the time spent, or whether or not the court in its decision has to cite particular authorities to state that, okay, this prisoner will now serve life in prison. Is that correct?
Well, yes. So he has a conviction of manslaughter. Manslaughter carries a maximum of life. We can see from the Rame Sunarayan decided in 2006, he technically got 4 years for his the killing based on provocation. In the one for Vishnuat Sharma, I didn't say the sentence, but the judge found a starting point of 15 years. Because he had always shown he wanted to plead guilty, he gave him a 1/3 discount, taking it to 10. And then he had been in custody for about 8 years. So eventually he only served 2 more. So that is 4 years, that is 15. Uriah Woods wasn't given a sentence. Sean Marcelin remains unsentenced, but I can tell you what happened in Anand Babulal, which is the 3rd appeal I had done about it. When the Court of Appeal upheld Sean Marcelin's submissions, I had also made it in Anand Babulal, and the state conceded, and they replaced manslaughter. Anand Babulal is a case, it caused me some trouble. The trouble comes from the sentences. Because I think the law of provocation needs reform, it would flow into the sentences that need reform as well. Because it would shock you. I would read, there's no written judgment. I'd only have to read from a news article. I'm going to read the April 2017 when he was convicted. Tears flowed from Anand Babulal's eyes after he was told that he would suffer death by hanging from the murder of a mother and her baby in Mayara 12 years ago. 12 years ago would make it 2005. The death sentence was read twice to Babulal. Babulal was convicted of killing a woman, 26, and her 18-month-old son, Ishmael Timothy Ragbir, in 2005. The deceased bodies were found in a pit of latrine at her home in 2005. There were stab wounds to her chest and her abdomen. And there's a current case in the public domain where, you know, a child's head was cut off. Yes. And I did think about Anand Babulal's case. In the appeal, this is 23 now. A man from Mayaro, well, this is the same Anand Babulal, will be released from prison in a little over 7 years. Anand Babulal was convicted of double murder in 2016, but last year Court of Appeal upheld his appeal and substituted convictions for the lesser offense of manslaughter. In sentencing Babulal this morning, the Court of Appeal began with a starting sentence of 25 years before deducting the time that he already spent in prison. Babulal was charged for murdering 26-year-old girlfriend and her son Timothy in August 2005.
Her son? Or
her son, not his son.
Okay.
Her body was found in a latrine at her home, while his son's body was found wrapped in a fishing net in the river. They had both been stabbed multiple times. During his trial, prosecutors relied on a confession statement in which Babulal admitted he stabbed Ramlochan and his son after she attacked him with a knife. He had relied on some kind of self-defense or provocation, which was rejected, convicted of murder. But here we have a double murder. The reason why... Yes, sorry?
No, you go ahead, because I'm interested and I'm sure
the reason why I have the difficulty with Anand Babulal's case, although it is my submissions, the Court of Appeal accepted. When we look at loss of self-control and provocation, and it would come to the
But did you explain, sorry, before you go there, did you explain the facts in terms of what happened?
Well, the facts really...
what led him to that act?
It appears some sort of mental illness or something like that. You know, although the court relied on provocation, you know, the diminished responsibility is a difficult defense. It's also a partial defense. Drops it from murder to manslaughter. I can't really explain why he did what he did. He didn't really have that level of evidence as the other accused had.
Okay.
You know, and I'm not taking instructions from him. I'm going at what happened at the trial. It appears to be something like that. It was reduced for the same reason that the judge asked the jury to examine the reasonableness of the reaction, not the reasonableness of the loss of sentence.
But reasonableness of the reaction to what? And this is what this is where this is where I'm going at in terms of if we're saying that there was a mental illness or some diminished responsibility, then of course with what led to...
What are the provocative
yes.
acts that would cause him to lose his self-control? Well, he relied on, she attacked him, and then also a number of relationship issues. And
that was basically the
like
time
breaking,
of the
yes.
the time of the offense.
Yes. So a build-up, a slow burn, cumulative provocation, relationship issues, nothing that people in relationships haven't suffered, but building up to the point. And, you know, it's a difficult topic because we shouldn't give excuses to things that happen to everyone, you know, and relationship issues. So the Anna and Babylal case causes me difficulty all the way on a strict application of law. Normally what happens, law develops, so Sean Marshland was decided, and then they realized, well, you know, provocation is some problems. It applied to Anna and Babylal. It applied to another case. They applied Sean Marshland about 3 times and quashed 3 convictions of murders. It's probably heading to the Privy Council maybe in a year, 2 years, with about maybe 4 different cases on the issue of provocation. I read this morning, Chief Justice and a 2-member panel, 3 members, had dismissed an appeal on provocation. So it has to be clarified. I think it needs to be scrapped entirely. I think we should adopt the UK position of loss of self-control.
And therefore, in order for it to be scrapped entirely, it means that legislation.
Because in Sean Marshland, I remember when we argued, Ms. Natai Lachman and in Uriah was in 2017, now retired Justice Narayan said, well, you're trying to change the law. And this is not, that has to be done by legislation. In Sean Marshland, they took the 75 pages. They set out the areas where they think could deal with some legislative reform. The criminal bar has written to the AG, included this. This case is, relatively new, June 2023. I have looked at the issue of domestic violence, intimate partner violence, and all this, and this is connected, and I've been reading a lot, you know, even the case of LC, and it needs reform. It could come as a proper package, but most importantly, the part we should adopt is that infidelity cannot be relied on as a ground for provocation. Because we, you know, I don't want to say we all get horn, but a horn is only if you take it on. Men need
easier said.
Yes, easier said than done. Easier said than done, but the level...
It's either you move on, you seek counseling.
Yes.
But it is very difficult as
a human being
to accept.
Yes.
But it is not, I don't believe that it is justifiable to use that as a defense.
Yes.
To murder.
Correct.
I mean, taking someone's life
yes.
is totally extreme as opposed to the offense, or rather the act of infidelity.
Yes,
you know,
I agree.
One has to weigh what is reasonable.
I agree.
And that's why obviously a lot of our listeners, of our viewers, listeners, would wonder or would be questioning in terms of whether the law is whether the law is really fair.
No, the law, no.
Right? And this is why a lot of persons have issues with the justice system.
Yes.
More particularly where you have a lot of common law practices that has not been evolved by virtue of statute.
Yes.
And but then how do we make representations to the Law Review Commission, or rather to the government in terms of
yes.
the criminal bar?
The criminal bar has quoted the appropriate sections where the judges have mentioned, well, we interpret law. What you're asking, Mr. Khan, we kind of agree with you. We don't want to say we agree because, you know, separation of powers, addressed it to the AG. So a week after, we sent it to the AG. We'll send it to the law reform. We believe on another topic that murders need to be categorized, you know, and the case of LC is one. Wife killings, spousal killings all need the unique reform. And it can't be done by judge-made law. It has to be done by the legislator, and we're hoping to push it in this direction. These cases and the public outcry highlight that. So it's time for reform. A loss of self-control will always be here, but it should never be.
Well, we've been hearing we hear about reform. Reform is a very common word, but it sometimes it's just bandied about, and there's so many areas of law. I mean, to be fair, there are many areas of law that has been evolved over the couple of years. Well, I am not a criminal attorney in terms of criminal practice. I only practice criminal my first year in practice, and it's a very interesting area of law. The reform in terms of now having the criminal proceeding rules and all these different things. But I believe if we separate from common law and actually create legislation to solve ambiguities or interpretations within the law, is it that, and this is a question I'm going to pose to you, is it that you would see things being progressive?
Yes. Common law is decided case by case, and therefore they say difficult cases make bad law, because it's hard to get the justice of the case. So you need an overarching legislation. There could be room for interpretation of the judges. You don't have to cover everything. The case of LC that you discussed with Mr. Ramke soon, to me that was a clear case of self-defense. The fact that she had multiple stab wounds on the deceased, to me, does not take it out of self-defense. She probably stabbed till she felt safe. But because the law on self-defense requires, you can't be excessive. So the entire...
But then who decides excessive? I mean, if you are a person that is in immediate fear of violence, and even not fear of violence, but fear of death. Someone said, I'm going to kill you tonight.
Yes.
Then
the case of LC, I think, is a perfect example to show why we need categorizations of murder. There's not just there's too many types of killings. So self-defense needs to be set out properly. Loss of self-control. There's all kind of problems with mental health, diminished responsibility, how we treat it. I don't think it could be properly handled by judges. Mr. Khan, Israel Khan, criminal bar has shown me documents 20 years ago where he submitted saying these have to be categorized. There's legislative agendas. Some of the legislation on the agenda looks very needed.
Yes.
But this has to be done, and I hope it will be done sometime soon.
Agreed. Daniel Khan, thank you so much. You always bring positivity and of course, in your work, congratulations once again.
Thank you.
Of course, and I thank you always for your input and your advice. So do you want to say anything before we...
Well, again, I'm grateful for being on the show. Watch most of you're continuing. Upwards of 75 episodes, going on to 80. These last few ones about partner domestic violence is very important. Protecting our women, equalizing the playing field. And I think shows like this do an excellent way to raise issues. And we won't stop here. We're coming to talk the issue, but we're drafting our suggested legislation reform, and we're working together to make the system a little fairer if we can. And I'm grateful for the opportunity.
Indeed. Thank you so much, Mr. Khan, and all the best. So, guys, it has been a wrap. Hope you enjoyed this informative and self-thoughtful episode of Strictly Legal on WASN Content Capital. And before I leave you with this quote: real change, enduring change happens one step at a time. God bless. Have a good day.